早晨各位同事就
Members, good morning. This is the second meeting of the Bills Committee on Inland Revenue Amendment Number 3, Bill 2017. The first part of the meeting is to meet with deputations, so may I invite the administration as well as the deputations in first.
咁提一提各位委員呢
Let me remind members that we have a letter dated the 11th of May 2017 from the Hong Kong Institute of Certified Public Accountants. It's been tabled. Would the administration please take a seat to my right? The letter's just been tabled, and the Hong Kong Institute of CPA will also be represented today. Good morning, deputations. Please be seated.
OK 好歡迎各位
May I welcome the representatives and deputations, and may I remind you that if necessary you can use the earpiece in front of you. Channel 0 is floor, 1 is Cantonese, English, 2 is English, and 3 is Putonghua.
I'm the participants of this hearing. You can use your headphone. The 0 channel will be the live channel. Channel 1 will be the Cantonese channel. Number 2 will be the English channel, and number 3 will be the Putonghua channel. And
I'd like to remind deputations once again that since we don't have a lot of deputations today, each deputation will be given 6 minutes to speak, and your speeches and submissions will not be covered under the Electoral Powers and Privileges Ordinance. And would you please also pay attention to the various security measures set out in the matters to note for members of the public attending meetings in the electrical complex. This notice has been attached to the letters sent by the Secretariat to you, and it's also in front of you if you have submissions or letters ready. And after you speak, before you leave this room, please give those to our staff. So may I first invite the Hong Kong Association of Banks, Mr. Yun, to speak. Thank you.
Chairman and members of the Bills Committee, I represent the Hong Kong Association of Banks and am acting chair of the Common Reporting Standard Working Group under Taxation Committee. We thank you for the invitation to give our view on the Inland Revenue Amendment Number 3, Bill 2017. Since January this year, our member banks have implemented requirements of the current legislation on automatic exchange of financial account information, or AEOI. For instance, banks are conducting due diligence to identify residents for tax purposes of their customers with the views to perform first reporting in May 2018 and beyond. This was a result of significant human, financial, and system resource investments that banks have made in the last few years. Hong Kong is an important international financial center, and its ability to deliver on its AEOI commitments, as perceived by the international community, such as the OECD and the EU, is key to maintaining this position. The government has done much to pursue the new international tax agenda in the areas of information exchange, tax transparency, and the fight against tax evasion. For these reasons, we recognize the drivers of the bill and would lend our general support to the proposal. Considering the timing of the bill, it is crucial to disseminate up-to-date and consistent messages to the public and information institutions alike, financial institutions alike. To reflect the practical changes and impacts, the government should take steps to update its official information sources, such as the posters, APIs, taxpayer pamphlets, guidance for financial institutions, etc. Upon passage of the bill, we have included specific definitional matters in our submission. We also believe that the government will be in a position to take necessary steps and measures to accelerate the expansion of Hong Kong's comprehensive double tax agreement network with our current and prospective trading partners to further enhance Hong Kong's economic growth potential. As I indicated earlier, our members have made genuine efforts to achieve necessary compliance with the current legislation on AEOI. These efforts have been strenuous, as the implementation practically touched on all of its businesses and operations within the banks. Aside from adding 72 reportable jurisdictions, the proposal includes specific one-off requirements to collect and furnish account information for the second half of 2017 within a very short space of time. Under the circumstance, our members will need to further inject significant resources to review and update their existing policies and procedures, processes and control systems, governance, training and communication materials for the staff and the customers alike. It is not difficult to realize that it is tantamount to another mini AEOI implementation that needs to be completed within months. In a recent meeting with the FSTB and the IRD, HCAP and PWMA, that is Private Wealth Management Association, highlighted concerns raised by the industry and presented suggestions. While we understand that adopting some of our suggestions may not be immediately feasible at this point, we wish to nevertheless stress that one should not underestimate the efforts and complexity involved in the delivery of additional compliance requirements in a short time. We would therefore like to take the opportunity today to share some of the challenges for the committee's consideration. To help manage the burden on the first reporting, we suggested that banks could be made responsible for holding the relevant data for all 72 newly added reportable jurisdictions, and only provide the data to the IRD for those jurisdictions with which Hong Kong has signed an AEOI agreement. Similarly, the government could consider allowing banks as an option to submit data for the full year of 2017 for the 72 new jurisdictions in order to do away with extensive changes that will be necessary to handle a one-off item to report on a 6-month basis. Under the current legislation, banks are required to follow the so-called targeted approach to the due diligence requirements. It should not come as a surprise that banks adopting this narrow approach will incur significantly higher efforts and investment in completing due diligence for pre-existing customers within the remaining months of 2017. Specifically, the number of high-value accounts will surge due to the inclusion of 72 new jurisdictions, as opposed to Japan and the UK only. In closing, the chairmen and members of the Bills Committee will undoubtedly be able to ascertain that banks should ideally be allowed more time in which to implement the proposal.
Next we'll have Mr.
Thank you, Mr. Yuan. Next, Mr. Peter Stein.
Thank you. Thank you, Councillor. I wish to also thank the Legislative Council for giving us this opportunity to share with you our views. Some quick background about our organization. The PWMA comprises 47 member firms, all of whom are authorized institutions and licensed corporations in Hong Kong. with dedicated private wealth management businesses providing personalized banking and portfolio management services. You've already heard from Mr. Han Yun of the Hong Kong Association of Banks, and I wish to explain that PWMA members are mostly also members of the HKAB. We represent the interests of these firms in their capacity as private wealth management institutions, which sometimes involves specific interests and concerns distinct from those other banking institutions. In this case, PWMA and HKAB share a number of the same concerns about the implementation of the proposed legislation. That said, we do very much understand the drivers of this bill. We understand the need to implement the amendments to the existing legislation in a timely manner. And we fully appreciate that the global expectations around taxation and information exchange are evolving quickly, and that the SAR government should be doing its part to ensure that Hong Kong is able to meet these expectations to the standard that is commensurate with its status as a reputable global financial center. So I wish to state up front and for the record that PWMA is generally supportive of the government's efforts and the proposed expansion of the list of reportable jurisdictions. That said, it is important to note that the proposed changes will result in a very tight timeline for all parties. And this will make it crucial for the government to update its official information sources, which includes posters, API, taxpayer pamphlets, and especially guidance for financial institutions in a timely manner upon passage of the bill. It's important for the IRD guidance for financial institutions to clarify with respect to the additional 72 reportable jurisdictions, the FI's requirements, and that they are required to complete due diligence for new accounts, if not performed already, to identify reportable accounts, to complete the review of high value-added accounts before the end of 2017, and to furnish 6-month financial account data. While PWMA generally supports the proposal to expand the number of reportable jurisdictions, we believe it's important for all of our stakeholders to understand the key challenges that our members will face in complying with the new law. Basically, financial institutions will need to marshal substantial resources, human and financial, in order to implement the proposal within the second half of 2017. They will be required to complete a comprehensive review of accounts held at their institutions to identify those that may be held by tax residents of 74 reportable jurisdictions versus 2 previously. For so-called pre-existing high-value accounts, for individuals, that includes those who have 7.8 million Hong Kong dollars or more in their accounts, which is essentially all of the private banking clients of PWMA member firms. That review will require more time and resources than for ordinary retail banking clients. While many PWMA member firms have adopted the wide approach, those that have adopted the targeted approach will be highly disadvantaged in meeting that new demand. These concerns were previously shared in a meeting that we and HKAB held with the Financial Services and the Treasury Bureau and IRD on 24th of April. To whom we made the following suggestions. We suggested, as Mr. Han noted, that financial institutions be made responsible for holding the relevant data for all jurisdictions and only provide the data to the IRD for those jurisdictions with which Hong Kong has signed a bilateral competent authority agreement. That suggestion was made with the intention of minimizing the operational risk around providing large amounts of one-off 6-month data with respect to so many jurisdictions at one go. We also suggested that the government should consider allowing financial institutions as an option to submit data for the full year of 2017 for all of the 72 newly added reportable jurisdictions. That would lessen the heavy burden of the need to manage and submit 6-month data on a one-off basis as opposed to the usual full-year reporting thereafter. And we noted that FIs that adopt the required targeted approach will be strained in completing pre-existing customer due diligence for a much larger pool of high-value accounts in 6 months with respect to the 72 newly added reportable jurisdictions as opposed to Japan and the UK. This is particularly the case for any PWMA member institutions that adopt the targeted approach, since the customer due diligence for pre-existing high-value accounts will require more time and resources than for ordinary retail banking clients. While we recognize the rapid pace at which the new AEOI provisions have to be legislated, we urge the government to recognize that banks will have made their best efforts to implement the requisite changes within a very short time frame. Thank you very much.
Thank you, Mr. Stein. 跟住呢，下一位係香港會計師公譚先生。譚生唔該你。
Next, Mr. Tam from the Institute of CPA. First of all, I'd like to thank the chairman. The Institute of Chartered Public Accountants in general support the proposed amendments to the ordinance. We appreciate that Hong Kong has to be aligned itself with international standard in respect of the AEOI. In our submission, which was sent yesterday to the Bills Committee, there are only one or two concerns that we have raised in our submission. First of all, the reporting jurisdiction. I think that is only the first step. As I understand it,
the AEOI arrangement with the EU members before the end of the year, okay, or before the end of 2017. Now, I think we should have a more concrete timetable by the FSTB on how to meet that objective of having a AEOI arrangement with all the EU countries by the end of the year. Okay. And then the second concern 就係嗰個74。
Second concern is about the 74 countries. If we remember correctly, according to the proposal by the FSTB, we know that the other parties would need to satisfy the privacy requirements before we would sign the AEOI agreement with them. Looking at these 74 countries, for some of them, we have very limited commercial transactions with them. And secondly, we also have some reservations as to whether they would be able to fulfill our requirements. The likelihood of, arriving with an AEOI, agreement with these countries would be rather remote.
To the list, okay. 例如舉個例先啦，好似啊。
For example, Lebanon, Kuwait, Vanuatu. First of all, it's very remote that we may be able to sign a treaty with them. Why then do we need to include them as one of the reporting jurisdictions? That's one of our concerns. Perhaps the SAR government can explore or explain.
To have AEOI of reporting jurisdiction with those that we have tax treaty with, or union members, or whoever show the interest that they want to have AEOI with Hong Kong. I think we have to make a distinction here. Okay. 咁第三
After all,
it still really hinges on the definition of residence. Okay. And on the self-declaration, I know that I'm not a resident of a certain countries, for example, but the bank would think that I may have. Okay. So information is being sent through the IRD to the other jurisdiction without my knowledge on what information has been sent. Okay. I
think there is a need that the individual concerned should know. So that if I can foresee that there will be issues coming from the other jurisdiction. Taking myself as an example, then I would need to be prepared.
我哋覺得可能政府應該可能係考慮一下嘅啫。
These are the three concerns which we hope the government will take into consideration. Thank you, Mr. Tam. I'd like to remind you, Mr. Tam, that in any hearings of this council, it will be best that you either speak in Cantonese or entirely in English or Putonghua for the interest of our interpreters. Thank you very much. Next, we have Madam Lee Shuk Yi. You have 6 minutes, Ms. Lee. Good morning. I am more in favor of the proposed amendments, but over the last few years, there have been many amendments for the industry and the relevant, facilities the government provides and the extent to which we need to report such information. Are you going to adopt the system of the EU or what? So I think the onus on report or making reports rests with the FIs, the IRD, and the regulators such as the Monetary Authority. They should come up with more guidelines explaining what we should do. For example, you can take reference of the Singapore's practice. They have anti-phishing policies for their banks. What does that mean? It means that if you require certain information, if a certain country would like, a certain jurisdiction is interested in obtaining certain tax information regarding its residents in our country, you have to tell us specifically the exact time and date and the amount involved. If you could tell us that, and if I could identify the information from the monetary or financial institution, I can provide you with them, instead of just giving me the name and I'll look up all the information. I think we all agree that we should enact legislation to combat tax evasion which crosses national borders. We have no qualms about that. But as far as implementing such a measure, we have to consider the pressure put on the trade. For example, what will the pressure on the banking industry? Do the banks only need to teach their frontline staff as to what information they should provide and which they should not, and how much disclosure we should make? And I think here we need more supporting measures to help us. We also need to consider the protection of privacy for our clients. If somebody just gives you a name, you should not just provide all the information about that person immediately. But I don't see any detailed, information that can assist us here. I'm basically speaking against the anti-phishing provision, and I'm concerned as to how we can help the frontline staff to really comply. I hope that there could be more guidelines. If the proposal is too stringent, it would adversely affect the development of the industry. If it is too lenient, it may affect the privacy rights of our clients. Thank you, Ms. Lee. Well, the deputations have already spoken. Does the administration have any preliminary response? Mr. Lai? Thank you. And good morning. I'd like to thank the deputations for attending the hearing this morning. When the government contemplated the amendment of the IRO and to incorporate the reforms for the AEIO regime, beginning in March, we started to meet with different deputations and conducted briefings to help them understand the purpose or motive of our proposed amendments. I would like to first of all thank the 4 deputations, including the Institute of Banks and also the Private Wealth Management Association and the Institute of CPA. They have all expressed their support for our proposed amendments, and they expressed their understanding that international tax cooperation is proceeding very rapidly. Hong Kong, being an international financial center, will need to come up with an appropriate response. So first of all, I'd like to thank the deputations for the support. We also understand that these new requirements will certainly impose additional compliance burdens on the financial institutions, the banks, and so on, in terms of the manpower, IT system, and client liaison. It would mean more work for them before they can comply with the requirements. Regarding the resources they would need to commit to the task, in order to comply with these requirements, we fully understand. We hope you will understand also that for the present amendment exercise, we are basically following, we want to align ourselves to the common reporting standard of the OECD, and this common reporting standard is also applicable to all the 108 jurisdictions which have signed on the AEOI system. As Ms. Lee said, Ms. Lee asked whether or not information we are requiring is too limited or too excessive. We're basically following the OECD, standard, and whatever they require, information they require, we would require the FIs to also to supply them accordingly. I also like to make a preliminary response to some of the views made by the 4 deputations. First of all, what are some of the follow-up work that we will do so that after the enactment of the amendment, the implementation of the provisions will be smooth. Some deputations also make some suggestions and ask certain questions, and later on I will be making some preliminary responses. As far as implementation is concerned, we are grateful that over the last 2 months, many deputations and chambers of commerce have submitted their views to us so that we could do a better job in terms of the amendment of the ordinance. We fully agree with the Association of Banks and the Institute of Private Wealth Management and the proposals they put forward. For example, the ILD is now making preparations so that if the amendment were enacted, we will upgrade the guidelines for FIs so that they will know what are the new arrangements. And secondly, we agree with the 2 institutes' proposal or submission that publicity and education are important. We need to let the public and our clients understand about such requirements so that they would be more willing to work or cooperate with the FIs and the banks when they make inquiries of them. And the AEOI was implemented in January this year. At the end of last year, we already produced some posters and pamphlets for financial institution banks, which put up in conspicuous locations. We've also have broadcasted some APIs on radio stations and TV stations. This time we will, upgrade, or we will amend the APIs and we will promote that there are 70 jurisdictions which are now added to the list, so that your customers will be reminded that last year it was only Japan and the UK which were all the reportable jurisdictions, and it will be a long time before it will be their turn. But this time we are including 75 jurisdictions. 73 are new jurisdictions which will be put onto the list of reportable jurisdictions. We believe that we need to highlight that message for the public and also for your clients. We'll certainly follow up on the promotion side. Also, our colleagues from the Institute of Banks and the Private Wealth Management Association also mentioned that for the banks are concerned, they will be under a lot of pressure in terms of compliance is concerned, and they asked whether or not we can allow them more time. There was a suggestion that if the ILD has not yet signed the multilateral convention with some jurisdictions, then such information can rest with the FI for the time being and will not need to be submitted to the ILD. We understand the rationale of that request because this would give the FI more time to collect the information. But I hope members and the deputations will also understand that such exchange of information between Hong Kong and the OECD member states is an international obligation. So we are very concerned. The first time, next year, for the first time, when we exchange such information, we want to make sure that we do a proper job. So we want to play safe, so that for the banks and AFIs, if they've collected the information, and with the amendment of the bill enacted, for the 73 jurisdictions, the relevant client information, the FI will need to collect them. And by May 2018, when the IRD requires submission of such information, the FI will need to comply. We
hope that the FIs will be able to submit an intact set of data to the IRD for the two purposes. First, the IRD, or the government, can review the implementation progress, whether it's satisfactory, and if there are problems, we can deal with them as soon as possible. On the other hand, we're also concerned if FIs only submit information needed for automatic exchange immediately first and then submit other information later, then if something untoward happens, let's say if there is any loss of data by FIs, it is still Hong Kong's responsibility to fulfill the requirements. We believe that if comprehensive data can be submitted to the IRD as soon as possible, then the IRD will protect the data in its comprehensive system so that it will help us fulfill the AEOI requirements. The second point I'd like to respond is this. The two associations just now mentioned whether we can allow FIs an option to provide data of the full year of 2017 instead of just the second half of 2017. Well, we have taken this into consideration, but the objective of this amendment bill is for the FIs to provide data in relation to the second half of 2017. Thereafter, they'll be required to provide full-year data. Earlier, when we discussed with the OECD, we understand that it was the OECD's wish that Hong Kong should provide the full-year data of 2017. But in order to implement that, we need to amend the legislation and make clear the requirements needed for FIs to execute. Although FIs at the moment are taking the wider approach in collecting clients' data, some FIs, however, would like to take a targeted approach to collect data relating to reportable jurisdictions under the new requirements. So, having discussed with the OECD for some time, we explained that since we need to go through the legislative amendment and we need to give FIs time to collect data, we only ask for the second half of 2017's data to be submitted. Of course, for the OECD, they definitely would welcome the submission of a full-year data of 2017. Our concern, however, is that if we provide this option to FIs, there may be some unnecessary misunderstandings with their clients or inquiries from their clients, because if the OECD's basic requirement is for Hong Kong to submit data relating to the second half of 2017, and if some FIs then submit full-year data of 2017, some clients may raise questions as to whether this is necessary. And we want to avoid the unnecessary dialogues. We believe that this may be more helpful for clients and FIs if our requirements are clear. For FIs adopting a wider approach in collecting clients' data, definitely submitting a full-year data would be much easier than submitting a 6 months data. However, we hope that they will understand this one-off requirement because of the circumstances as mentioned. On this occasion, only second half of 2017's data will be required. After that, full-year data will be submitted. And just now, Mr. Tam also mentioned that with the EU and other countries in the process of deciding whether we would implement exchange of information with them, our consideration is as follows. Now, on this occasion, we have included 73 new reportable jurisdictions, and they basically come under 3 categories. The first category is the EU countries, 28 of them. We understand that they have this stringent requirement, and in order to fulfill their requirement and avoid being listed as a non-cooperative tax jurisdiction, we need to include all 28 EU countries. And we also have some 40 CDTA partners, and we have included all these partners. The third category is some 60 countries which are members of the OECD, which have expressed an interest in conducting a EOI with Hong Kong. Of course, there may be some overlapping under these 3 categories, so we've consolidated all the jurisdictions, and together with UK and Japan, altogether we have 74 jurisdictions. And Mr. Tam just now said that we'll be keeping a close eye on the exchange of information, and Hong Kong will definitely sign a BCAA with the jurisdiction concerned, or that after we become a member of the multilateral convention, only after these 2 have been done will we implement the AEOI. We will not automatically implement the AEOI with the 75 reportable jurisdictions. Mr. Tam just now also mentioned the privacy and confidentiality issues. We also attach great importance to these issues. Therefore, in relation to the jurisdictions concerned, they also have their own requirements on privacy and confidentiality of information. Last year, after being assessed by the OECD, Hong Kong has been considered qualified in implementing the requirement, and we understand that for at least 100 jurisdictions around the world in the network, there are still jurisdictions that have yet to meet the standard, and the OECD will not make this list public, but we, internally speaking, are aware of that list, so that after we have signed BCAAs with the jurisdictions, or after we have joined the multilateral convention, we will still in future make sure that for the partner of the AEOI, it will have to be assessed by the OECD as qualified for AEOI before we exchange information with the jurisdiction. I hope that this will give confidence to the public. And Madam Lee just now also mentioned that in exchanging information, we should require the jurisdiction making this request to set out the specific details. I think Madam Lee was referring to the EOI request, but under the existing legislation, the tax authority, the other jurisdiction can require exchange of information with us, but for this proposal, it is different. For AEOI, we have a common reporting standard on what information is to be exchanged. The OECD has set out the necessary requirements for compliance. Second point, information will be exchanged on an automatic basis. As long as there's a BCAA, or if the jurisdiction is a member of the multilateral convention, AEOI will take place. And also for exchange of information, as mentioned by Madam Lee, we also have this existing practice, but this is the IRD's principle that the other party must be able to submit to us grounds of requesting the information and the specific information required before we follow up on the request. For fishing activities, as suggested by Mem Lee, if the other side is unable to provide specific information or specific reasons for requesting the information, then there is a reason for us not to comply with their or accede to their request. So we do have procedures to follow in this regard, and this is my response to suggestions or issues raised by deputations, and I welcome questions or comments from members. Thank you. Thank you, Mr. Lai. I'll give 6 minutes to Ms. Wong Ka-ying from Civic Party to speak as well. Thank you, Chairman. In principle, the Civic Party supports the proposal for Hong Kong to comply with the OECD's AOI requirements. In terms of today's amendment bill, we like to raise our concerns. Just now, according to the response, well, our concern is that last June, another bill relating to inland revenue was passed. It was done in a short period of time. And then, since the passage of the last bill in June this year, we already have another bill in less than a year's time. And the time frame is too short. We are concerned about that. And we understand that the first round of submission isn't required until 2018. And we'd like to know the preparation done by the government and the progress. And also, since the first exchanges will not commence until the end of 2018, why can't we wait for a comprehensive overhaul of the list in one go by then? And we're also concerned whether we're able to exchange information with those jurisdictions at the moment. Anything to add, Mr. Lai? Thank you, Chairman. Madam Wong just now raised a few points. I'd like to respond to them. First, I think the concern raised by Mem Wong was also echoed by the industry that we only passed another bill last June. Why must we hastily propose another bill? But the international developments have been taking place rapidly. We originally would like to adopt a more progressive approach in implementing the proposal to minimize the burdens of compliance, burdens on financial institutions, and that is why we're adopting this approach. At first, we discussed or negotiated with the individual jurisdictions in drawing up bilateral competent authority agreements instead of joining the multilateral convention. More than 90 reportable jurisdictions in the world require FIs to adopt a wider approach to collect clients' data, whereas we only require a targeted approach in Hong Kong, focusing on the list of reportable jurisdictions. Our objective is to minimize the burden on FIs. But last year, after the bill was passed, the OECD expressed concern about Hong Kong because if we take this special approach and if we implement the proposal by BCAAs, the OECD's concern is that many member states will not be exchanging information with Hong Kong until very much later. And the OECD was concerned about our progress, and the OECD and the EU The OECD already expressed that they would conduct a review on the AEOI arrangements, and if necessary, they would draw up a list of non-cooperative tax jurisdictions with countermeasures. And that is why we need to expedite our progress.
I understand that the timetable is rather tight. So once we were able to contemplate this proposal, we immediately informed the FIs so that they would be prepared. The first time when they submit information to the ILD, it will be July next year, so you have May next year, so you will at least have almost a year. Regarding the timing for the exchange, the ILD and the other tax jurisdictions, the first time we exchange tax information will be the middle of next year. So the ILD will require the FIs will, in May or before that, submit such relevant information to us. If the amendment is enacted, then the list to be submitted will involve 75 jurisdictions. This is the first time that we will be collecting such information from FIs, and it will be the first time for Hong Kong to exchange its information with other jurisdictions. We hope that the exchange will be able to be conducted smoothly. The ILD certainly will be issuing detailed guidelines for the FIs. I also hope that the FI representatives can rest assured, because in our earlier discussion, some of them have expressed their concern to us. That is, under the IRO, there are penalties. Non-compliance may result in penalties and liabilities. We already explained that if we want to comply with the AEOI requirements internationally, we must work together with the FIs to obtain the relevant information. We want to ensure that the information are accurate. Therefore, the FIs, in order, the law would require that the FI would conduct due diligence. But we also understand that at the initial stage, if the FIs require more guideline or guidance, or if they have any technical issues that they would like us to further clarify, then we would certainly deal with the question of enforcement in an appropriate manner. Our penalties are targeted against total non-compliance, or those who deliberately provide false information, or people who have actually, falsified information. Thank you. Mr. Chen Chen-Ying. Thank you. First of all, I'd like to point out that we're talking about 73 and not 72 jurisdictions, because today we are considering whether or not we should add Turkey to the list. And South Korea today, the timing will, the reporting year will be 2019 and not 2018. For some countries, the year we start to exchange, I think we need to follow the OECD. If Korea is only ready in 2019, can we also issue a notice to the 70-odd jurisdictions and ask them whether or not they really need to have the exchange done in 2018? If they're only ready in 2019, 2020, then we don't need to rush and provide the deadline of 2018 in the bill. I think that can address one of the concerns expressed by the deputations. Secondly, the last time we met with the FSTB and the OECD over lunch on that occasion, I also asked the same question. The deputation said that for countries for which we have not yet signed a treaty with, can the information be kept by the FIs for the time being? And the Permanent Secretary said no, it would be best that it be kept by the ILD. I asked that if the information not yet ready, then the ILD should not exchange such information. The Deputy Secretary has put it more clearly today, saying that there is a mechanism to ensure that only after certain conditions have been met will we exchange information. But I hope this will not be just an internal mechanism. Could you publicly disclose what conditions will need to be satisfied before the ILD will exchange information with another jurisdiction? Can you spell out, what the mechanism is and what are the guidelines? Thirdly, next week we're going to have the meeting of the Constitutional Affairs panel about exchange of information across national borders. And of course there are exemptions under the proposal. One of the exemptions is consent by clients. If there is consent by clients, then you are free to exchange such information. The Institute of CPA made one submission. That is, after the information has been exchanged for the individual concerned, it would mean that many jurisdictions in the world can use such information to determine the origin of its wealth. So therefore, they hope that there could be a clear-cut mechanism so that the client can make data corrections. So in the guidelines the government will provide in the future, the Permanent Secretary said that there will be new guidelines for the FIs as to how they should collect and manage such information. I hope that the mechanism for the updating of information should be clearly spelled out in the guidelines you will provide, because that can get, only then can you give the assurance to the clients. And finally, many clients of banks do not know that previously there was only UK and Japan. Now the reportable jurisdiction is increased to 75. You said that there would definitely be promotion and public education. I'm worried that the government is working on so many different projects at the same time. Could the FSTB promise that when you conduct education regarding the AEOI mechanism, how much funding will you commit for that purpose? How much you will spend on advertising and so on? So could you give us some indication to prove that there will be sufficient resources to help the society understand these requirements? Otherwise, the onus will rest on the shoulders of the FIs. Thank you. Mr. Lai? Thank you. And thank you, Mr. Chan. I'd like to thank Mr. Chan for the many valuable submissions he made to us reflecting the views of the industry. Mr. Chen raised 4 issues. Let me deal with, first of all, the mechanism triggering the AEOI. Mr. Chen is concerned that we are now putting 75 countries into the reportable jurisdictions list. When are we going to exchange information with them? There are 2 considerations here. First of all, in the law, we already spell out that Hong Kong must have established an AEOI mechanism with that jurisdiction. Right now, we're talking about the bilateral agreements, but we've also explained that we are actively considering to apply the multilateral convention into Hong Kong. If Hong Kong joins that convention, it will become a new platform for Hong Kong to exchange information with more jurisdictions. So we need to first of all build up that platform. And secondly, in my 04 response earlier, I said that we understand that the need to maintain confidentiality and making proper use of the information is important. It is also in the guidelines of the OECD. For all jurisdictions joining the AEOI scheme, the OECD would assess their confidentiality mechanism. The OECD has stipulated that if there are any jurisdictions which have problems with the confidentiality arrangements, and if the OECD is not satisfied, then the other jurisdictions will not exchange information with that country. As to which countries are considered to be non-compliant, the OECD will list them on their website. For the other 100 jurisdictions, the tax authorities would know, although it's not published on the website. So we follow that guideline. Secondly, Mr. Chen asked whether the present amendment would conflict with the Personal Data Privacy Ordinance. The present amendment does not really affect the Personal Data Privacy Protection Ordinance. This time we are talking about amending the list of reportable jurisdictions and the timing for the collection of data. Regarding the FIs and how the FIs deal with personal data of the customers, we still would abide by the basic requirements of the OECD. This is reflected in the amended framework enacted last year. That will remain unchanged. The IRD will issue new guidelines for the FIs to reflect the changes proposed in this amendment, and also the details which have been updated by the OECD recently. So these will be included in the guidelines we will give FIs. Mr. Chen is also concerned about publicity. Perhaps after the meeting I can collect the relevant information. Since October last year, we have, through TV and radio stations, broadcasting APIs to help the public understand this, topic which not many people know too much about. In producing such APIs, of course, there will be a one-off expenditure incurred, but for these APIs broadcast on radio and TV stations, we are given a free quota. So when we broadcast more of such APIs, it doesn't mean that we have to incur more expenses. Perhaps I can supply the information for members after the meeting as to the number of times we've broadcast the APIs in the last 6 months. Of course, with the amendment enacted, then from June to August, we will certainly step up the promotion on the amended requirements. We hope that this can also help the FIs when they inform their clients. Finally, for South Korea, the timing for exchange will be 2019, which is different from the other jurisdictions. So the OECD, as far as the AEOI is concerned, has provided for 2 timetables. For the first batch of jurisdictions, it should be the second half of this year when we start to exchange information. The latest will be for the second batch, 2018. So for Hong Kong, we've chosen 2018. But as for Korea, why is it so special that it's only in 2019? Because early this year, through bilateral negotiation, we arrived at the AEOI arrangement with Korea. For the bilateral agreement we signed earlier this year, I think Hong Kong will need to amend the law. After that, we will put the name of those jurisdictions into the schedule of the IRO before we can ask the FIs to comply. So if we put Korea and relevant jurisdictions onto that list in 2017, the FI will need to collect the information of the clients in 2018, first submission 2019. So for the few new agreements that we signed earlier this year, the jurisdictions know about this timetable. But we also told them that we're still talking to the OECD. We may need to bring it forward. So the information for the second half of the 2017 we would exchange with other jurisdictions. For those countries which proactively talk to us about bilateral agreements, if the OECD, now if we are going to bring forward the collection of information in 2017 and exchange of information in 2018, that arrangement will be extended to those countries we've signed bilateral agreements with early this year. Only then would it be fair, so that those countries which have proactively signed bilateral agreement with Hong Kong would collect information at a later stage, and whereas those who come at a later stage will receive the information earlier. For those countries that signed bilateral agreement with us early this year, we tell them that we can exchange with them the information for the second half of 2017 in 2018. All jurisdictions welcome that except for Korea. They prefer that we use the original bilateral agreement. That is, we collect the data for 2018 and then we can send it to them in 2019. So we've accepted this request, and that's why we've amended the law. That is, the reportable year for all countries will be 2018 except for Korea, which is 2019.
Mr. Chan, do you have other questions for the deputations or individuals? No, thank you. All right. The first part of this meeting is to meet with deputations, and we have done that. I thank deputations for coming. If you have written submissions, please leave them with our staff. Thank you. I remind members that at the last meeting we basically finished the clause by clause examination of the bill, and at today's meeting the administration has two papers for discussion. One is CB bracket 1915/1617 bracket 02, which is a follow-up to the meeting on the last meeting. The other paper is CB bracket 1915/1617 bracket 03, which is the draft CSAs proposed by the government in relation to this bill. So we have two papers. So would the administration please walk us through these two papers? Mr. Lai? Thank you, Chairman. Let me first brief members on the supplementary information responding to the issues raised at the last meeting. There are two questions. First, what were the criteria and considerations for including jurisdictions in the list of reportable jurisdictions? And second question, whether we would consider prescribing the criteria or considerations in the ordinance. Now, about the list of reportable jurisdictions, we're going to have 75 jurisdictions, and as pointed out in the paper, we have three criteria or considerations set out in para 3, and I also explained the points in the first part of the meeting. For example, the jurisdiction should be a member of the European Union, or the jurisdiction might be a prospective AEOI which have indicated an interest for conducting AEOI with Hong Kong, and we have therefore included those jurisdictions in Schedule 17, Part 1 of Schedule 17E. And in order to give flexibility to the list, we don't consider it necessary to include the criteria in the law, because our consideration has been set out in the policy paper submitted to LegCo, and in the future, if we further amend 17E, we need to submit our proposal to the Legislative Council for negative vetting. So we're going to adopt a negative vetting approach, and the Council will definitely be able to consider if the administration's proposal is appropriate or legitimate, and we do not want to further complicate the ordinance or make it too rigid, since the Council will be able to address the concerns by negative vetting. As for the CSAs, we have two simple technical amendments. First, we will include the Republic of Turkey in the list because the Secretariat of OECD recently suggested to us that there are two countries which are members of the group of 20 not on our list. First is US, second is Turkey. For the US is simpler because it is not under the AEOI network, whereas for Turkey it is an important member of the G20. The OECD therefore has suggested that we include Turkey for the time being in our list. But as mentioned just now, we are not going to exchange information with Turkey right away. We need to go through either of the channel, that is the BCAA or the Multilateral Convention, for the exchange of information. The other point, as raised by Mr. Ronick Chen, for our AOI partner, Korea, will exchange information with the partner starting from 2019 instead of 2018. So that's what the amendment is about. Any questions from members? I do have a question about the Korea's amendment. You're going to amend the year of commencement at the level of the OECD. Have they expressed any concern? How come they can amend the year of commencement, whereas for other jurisdictions, they have to fully comply with the OECD's requirements? Yes, I understand your question, Chairman. For Korea, the situation is quite unique because we reached a BCAA agreement with Korea on exchange of information, so it's up to both countries to decide the year of commencement. Whereas for other jurisdictions, it has more to do with their commitment to the OECD, and that's not our concern. As Korea has proposed to commence exchange of information starting from 2019, I believe that we will be able to give an account to the OECD. So, Mr. Lai, in relation to the OECD's requirement, I'd like to know what exactly it is. Does it mean that by the end of 2017 we must include the list of 75 reportable jurisdictions in our local legislation, and that we should conduct AEOI with them? Is that the assessment criteria? In the background or in the electoral brief submitted to this Bills Committee, there are 3 criteria for consideration. That is, first, to consider whether we are on schedule in implementing AEOI, and second, whether we have a comprehensive BCAA mechanism or that we have joined the Multilateral Convention so that we can expeditiously and comprehensively exchange information with the partners. And third point, whether we're able to exchange information relating to 2017. And we explained to the OECD that if Hong Kong is required to exchange a full-year data of 2017 with other jurisdictions, it may be difficult for us because we have yet to commence the AOI, but we promise we will discuss with the Legislative Council to exchange only data relating to the second half of 2017, and that was accepted by the OECD. The second point is the scale of BCAA mechanism, whether it will allow us expeditiously to exchange information with some 90 or 100 jurisdictions. And on the one hand, we will try to sign as many BCAs as possible. On the other hand, we'll also consider joining the multilateral convention to expedite the matter. For the agreement, are you referring to exchange of information on tax matters? Or is it also to do with the CDTAs as well? Or both? Well, perhaps I didn't make myself clear, Chairman. At the moment, through bilateral agreements with competent authorities, we exchange information on tax matters. It works at two levels. First, there must be a TIEA with the jurisdiction concerned, or the CDTA, Comprehensive Agreement on Tax Avoidance of Double Taxation. And we have these bilateral agreements with over 40 jurisdictions at the moment. But it is not sufficient because we need to sign another BCAA in relation to AEOI. That is why last year we proposed to amend Schedule 17E to add Japan and UK to the list, because with UK and Japan we already signed the CDTA with them. Last year we also signed the BCAAs with them, and that is why we included them in the list last year. For the CDTA and TIEA partners, over 40 of them, we have signed 11 BCAAs. Mr. Chen. Thank you, Chairman. I don't have strong views on the bill, but I want the administration to confirm this, because we're talking about AEOI. We also have AML, CFT, Basel III resolution regime, all these international requirements. And for this proposal, it seems that we, at the moment, are only meeting the minimum requirement, and we need to expedite the progress in fulfilling our international commitment. But we need to be aware of the fact that we compete with other jurisdictions around the world. If you adopt a more stringent approach, it will be disadvantageous to Hong Kong. I think last time some members also made the point. So it seems that we have expedited our progress in implementing AEOI. But it doesn't mean that, well, does it mean that in fulfilling international obligations, we are going to adopt only the minimum requirements so that our clients' interests or our business environment will not be undermined, and that we will not be put into a disadvantageous position? I agree with Mr. Chen entirely that as an international financial center, we must maintain our unique advantages. At the same time, we also need to play a role in fulfilling international tax cooperation or other financial requirements. Of course, we put Hong Kong's interests first, and for cooperation on the international front, of course, we want to meet the minimum requirement. This is our principle. Any comments on the proposed CSAs? Legal advisor. About the draft CSAs, we have read through the CSAs. I do not have any question on the CSAs, but I do have another question on the implications on PDPO, the Privacy of Personal Data Ordinance, because according to the administration, the amendment bill seeks to include the reportable jurisdictions under the AEOI network, whether or not they have signed a BCAA with us. Now, Section 58 of the Personal Data Privacy Ordinance provides that for tax matters or exchange of information on tax matters outside the jurisdiction, there is an exemption. If there is an arrangement under Section 49 capital A of the IRO, then there is an exemption, and that Sections 3 and 6 of the PDPO do not apply. And this description about Section 49(1) capital A will be deleted. I want to know whether the adaptation is right, because for some jurisdictions they may not have signed as an agreement, and the FI's concerns will still have to provide information. So does it mean that the account holder or the tax resident will need to give express consent before submitting information to you?
And thank you. Thank you, Legal Advisor, for the question. It is our view that this time we've made a technical amendment for we have for those jurisdictions which are reportable jurisdictions pursuant to 17A, and regarding whether we've deleted so we are able to, for the 73 new jurisdictions, they are added to the list. This is purely about the FIs collecting financial information. As I said, such information collected by the FIs will not immediately be exchanged with other jurisdictions yet. The exchange must be premised on Section 49(1)(a) of the IRO. That is, Hong Kong must have signed an agreement with the relevant jurisdictions, like Mr. Leung, the chairman, said. What are our considerations before we agree to the exchange? As I said, we must, rely on the current mechanism. In future, if there is the new mechanism of the multilateral convention, then we may need to have another amendment to the law before we can, do that. So under circumstances, the exemption requirements under the PDPO should not actually, be in conflict with our proposed amendment to the IRO. If members have no further views regarding the bill, I would like to invite the government to formally propose the amendments. I also like to ask the administration to provide a written version of your response to the deputations earlier. Once again, may I ask members whether you have any further questions regarding the Inland Revenue Amendment No. 3 Bill 2017, whether from the policy aspect or whether it's about the terminologies in the bill. Right. I think the arrangements proposed in the bill is appropriate, although I've heard some deputations suggesting that it's rather proposed too hastily and it would put some pressure on the FIs. I hope the government will provide as much assistance you can to the FIs. My last question is that you pointed out that the OECD conducted an assessment. When will conduct assessments? When will they come to Hong Kong to do that? Will they be sending a team? And what is the process of assessment be like? Chairman, I can share with you my understanding, and if necessary, the Commissioner can supplement. I think there are two parts to the assessment. First of all, for Hong Kong and all the participating jurisdictions, they will look at the mechanism for the maintenance of confidentiality. Last year, in the middle of last year, they came to Hong Kong, and after that, they were satisfied that we were in compliance. So they do conduct, a field audit. for the OECD to assess the participating jurisdictions to see whether or not to satisfy the 3 criteria and whether or not it's necessary to label them as non-cooperative jurisdiction. I don't think they may need to conduct a field audit because they now require us to submit reports every year, how many jurisdictions we've exchanged information and how many bilateral agreements we have signed. They would require us to submit such progress report. If they see that we're a bit slow, then they would make suggestions for us to expedite. Regarding the OECD's assessment of Hong Kong's exchange of tax-related information, they would do it in stages. In 2016, they have reviewed Hong Kong's confidentiality arrangements and whether laws are in compliance. In 2016, they sent a team to Hong Kong to conduct an on-site audit, and their conclusion was that Hong Kong was compliant. And they also are conducting the second stage audit to see whether or not our laws are in compliance with the OECD standards. For the third phase, but the review is now ongoing, I believe that going forward they will take a further look to see Hong Kong has effectively implemented the exchange of information and whether or not all jurisdictions interested in reaching AEOI agreement with Hong Kong, we are genuinely conducting exchange of information with those jurisdictions. The government hopes to resume the resumption of debate for the bill. Do you have a timetable in mind? The Secretariat has proposed 2 dates. Resumption of second reading, 7th of June 2017. If we adopt this date, then we will need to report to the House on the 19th of May. And any CSAs must be submitted on or before the 27th of May. The second date for the resumption of the second reading is the 14th of June, and if we choose this date, we will need to report to the House Committee on the 2nd of June. Deadline for submission of CSA will then be the 5th of June. Does the government have any views regarding those 2 dates? Chairman, we hope that the sooner the better. If we could do it on the 7th of June, I think we can give it a try and go for June 7th. We will provide the necessary information and written responses. We will, send them to the Secretary early next week so that we can finish the exercise. Early next week would be the 15th of May. I expect that by the 15th or 16th, the Secretary told us that you must give us those papers by the 15th otherwise we will not be able to report to the House. If you want to be expedient, please give us those responses on the 15th of May. Because we will need to read them. Members will also read the report before we can submit our report to the House Committee on the 19th of May. So you may need to work very hard this weekend. All right, anything else that members would like to bring up? I don't think we need to set the date for our next meeting. I hope the administration will give us the information by Monday, the 15th of May. I also like to thank members and officials for attending the meeting of this Bills Committee. With that, I now declare that we are adjourned. Thank you.